Council let us proceed. We don't have
We are proceeding under the law, Mr. Chairman. We have instructions under the EPDF Act, section 225, to appeal that particular ruling of yesterday. Subject is one as well, Mr. Chairman. And this particular provision, Mr. Chairman, provides that a party to the proceedings of a unit disciplinary committee or court martial, other than a field court martial, who is not satisfied with this decision, shall have the right to appeal to an appellate court on any or of the following matters: A, the legality or propriety of any or all of them. A, the legality or propriety of any or all the findings. So the accused persons are aggrieved by the decision on this issue. And under this particular provision, they are desirous of appealing the appellate court within the framework of the EPDF Act. So we pray that you be permitted to proceed.
No, Council, I'm not permitting you this time. Since morning we have talked about almost all laws, and we have been getting the same laws. Let's finish this process of pre-taking, and others will follow. Yesterday I had, we are done with Captain Ora on count 1, and this came when Makindye, that Dr. Kizza Besigye, was supposed to take plea. And now Dr. Kizza Besigye, on count 1, as you heard yesterday, do you accept or you don't accept?
Mr. Chairman, do I have the right to appeal the ruling that you have just made, or I don't?
I feel the appeal is done on the final decision of court, not on the ruling. So let us proceed.
And I believe that also knows that
Mr. Chairman.
Mr. Chairman.
Now what are you appealing on?
We want to refer you to that section 25 that a party to the proceedings of a unit disciplinary committee or court martial, other than field court martial, who is not satisfied with the decision, shall have the right to appeal on appellate court on any of all the following matters. 1, the legality or propriety of any or all the findings. The legality of the whole or part of the sentence, severity or leniency. It doesn't say that it has to be the final findings. So we are saying that this section gives our clients the right, automatic right, which is not debatable because it uses the word shall. If the framers did not want people to appeal at any stage of the trial, they would say so, and say that you can only appeal on the final orders. That is not the wording. So we would want to ask for copies of proceedings and certified copies of proceedings and ruling to enable us to appeal.
Sir, I have been clear. There is no appeal against the ruling. Let us proceed with the project. Appeal on the final decision of the court. The one is appeal with the head, which is the live vote.
Mr. Chairman, with your permission.
No, listen, I don't know which justice you are talking about because it is for both sides. For us all. Taking plea does not mean that the case is concluded. In fact, it is almost as if it has not started. So, taking a plea does not mean that the case is concluded, and I'm not allowing anybody to submit until we first finish this process. So Kano, that Dr. Kizza Besigye once again,
Mr. Chairman,
you accept or you not
I
accept?
decline to take the plea.
A plea of not guilty and
Sure.
That is the law.
Hajji Obed Lutale, have you had and understood the charge read to you on count one?
I decline as I told you.
A plea of not guilty and on count two, statement of offense. Featured under section 127 D of the PDF Act, Cap 730, particulars of offense. Captain Dennis Ora, Colonel Retired Dr. Kizza Besigye and Hajji Obed Lutale between February 2023 and November 2024, having right information regarding meetings solicit for logistical support with the intent to reduce the security of the defense forces, consciously withheld the said vital information from the proper authorities. So, Captain Dennis, Ora, have you had understood the charge read to you on count two? Come on,
I have heard and not understood.
and do you accept or you don't accept?
No, I don't accept.
A plea of not guilty entered in count. Dr. Colonel, that Dr. Kizza Besigye, have you had understood the charge read to you on count two?
I decline as before.
Hajji Obed Lutale, have you had understood the charge read to you on count two?
I also decline as before.
A plea of not guilty entered. Statement of offense on count three, and unlawful possession of firearms, under section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. None of that, Dr. Kizza Besigye and Hajji Obed Lutale on the 16th November 2024, while at the Riverside apartment in Nairobi, Kenya, they were found in an unlawful possession of a pistol model 27 KAL number 765, which is ordinarily a monopoly of the defense forces. Colonel, that Dr. Kizza Besigye, have you had understood the charge read to you on count three?
Yes, and I decline as before.
A plea of not guilty entered. Hajji Obed Lutale, have you had understood the charge read to you on count three?
Yes, but I decline.
A plea of not guilty entered. Statement of offense on count four, and unlawful possession of firearms, under section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel Retired Dr. Kizza Besigye and Hajji Obed Lutale on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, were found in an unlawful possession of a pistol model HB 1015 1953, which is ordinary monopoly of the defense forces. So, Colonel Retired Dr. Kizza Besigye, have you had understood the charge read to you on count four?
I do, and I decline.
A plea of not Hajji Obed Lutale, have you had understood the charge read to you on count 4?
Yes, and I decline.
A plea of not guilty entered. A statement of offense on count 5. An unlawful possession of ammunition contract section 4, subsection 1 and 2 of the Firearms Act, cap 320. Particulars of offense. Colonel Retired Dr. Kizza Besigye and Hajji Obed Lutale on the 16th November 2024 while at University Apartment in Nairobi, Kenya, were found in an unlawful possession of 08 rounds of live ammunition, which is ordinarily monopoly of the defense forces. So, Colonel Retired Dr. Kizza Besigye, have you had understood the charge read to you on count 5?
As before.
A plea of not guilty entered. Hajji Obed Lutale, have you had understood the charge read to you on count 5?
Yes, I decline.
A plea of not guilty entered. State.
The case be adjourned to the 3rd of February. For further briefing. And I accuse the persons being committed to their respective detention centers. 3rd February.
Mr. Chairman, Mr. Chairman, two requests or applications. The first one is in respect to section 225, which my colleagues alluded to. And I'm rising in light of the advice of the JA. The JA took review that the appeal, or the right to appeal, should not be exercised at the final stage, as I understood you. I hope I'm not misquoting you. Mr. Chairman, the reading of section 225, we read it a little slow, but it says, apart to proceedings of the unit disciplinary committee or court martial other than a field court martial who is not satisfied with its decision shall have the right to appeal to an appellate court on any or all of the following matters. Mr. Chairman, 225(1)(a) says the legality or propriety of all or any findings, and B, the legality of the whole or part of the sentence, and C, the severity or leniency of the sentence. Because this is a court and the matter before this court is of a criminal nature, Mr. Chairman, the finality or the final decision would come with either a sentence or an acquittal. And perhaps that is where subsection 1, paragraphs B and C apply. Subsection 1, paragraph A does not apply to a sentence, but applies to the legality of all or any finding. Mr. Chairman, a decision in this case is a finding. We want to distinguish it from a judgment, which, even though is a finding, is not a final finding. So in this case, there was an objection raised regarding whether or not the accused persons, 813, should take plea. They exercised their rights to raise an objection. The objection, as we have heard from the ruling handed down by the court, has been declined or has been dismissed. And that, in our view, is a finding and also a decision. It's not a decision in the context of a sentence so that A and B of subsection 1 can apply. It is a finding regarding the objections raised, one, and also the questions for the rephrase. So it is our request that, unlike the advice of the judge of the JA, the right to appeal envisaged in section 225(1)(a) and B is not at the end of proceedings. It is in respect to the legality or propriety of any finding, including the finding which the court has just handed down. So we do pray that the court permits that the accused person exercises their right to take the decision regarding the application for reference to the higher court. 2, Mr. Chairman, is that in exercising their right to appeal, as the sections envisage, in sections 227, is section 227(1), 2, and 3 requires the filing of a notice of appeal and also a memorandum. The memorandum can only be produced because the memorandum sets the grounds of appeal. We can only fine-tune them when we have obtained a record of the proceedings of what transpired in the submissions yesterday and today. The state has asked for up to 3rd of February. Today is the 14th. We have 17 days to end January, plus 3 is 20. We request the discipline force to, in the interest of the accused persons, use these days to prepare a typed record of appeal, which can be availed to counsel. So, record of proceedings, which can be availed to counsel, such that they can pursue the remedy available under section 225, which is the right to appeal. Mr. Chairman, in the other courts, there's a distinction, or in the law setting up the other courts, there's a distinction where a right of appeal is granted as of right, and where a right of appeal requires the permission of the court. In this case, it says that the accused person who is a party to proceedings, would be the state, or the accused person, has a right to appeal. That right, therefore, is not based on the permission of the court. So we are not seeking leave of court to appeal. We are advising the court that the accused person has got the right to appeal, and they are exercising that right. They are therefore asking to be supported as following messages, so that they are given a copy of the record of proceedings, prepare their grounds of appealing the memorandum. We also request that the court avails us a ruling, one which has been delivered a few minutes ago, and Mr. Chairman, you made an order that we avail a copy of the ruling in light of the objection which we have raised today. The registry and the state have not done so. They are not yet, because the order made by the chairman was lawful, they are not yet committing a service offense of disobeying lawful orders. So hope that they will oblige, because the ruling has been delivered and been signed, and perhaps that in your presence they will do at least that one, of giving us the copies of the rulings which are ready. Otherwise, we are likely to see our land friend Colonel Rafael on the 3rd of February, when we are lodging our application for contempt of your orders, Mr. Chairman.
I think Council, for the record of proceeding, that one has no problem, and even the rulings that we have made have no problem leaving on the matter of project.
Mr. Chairman, before the delay comes in, when court pronounced that it had no problem with us getting the copies, the state and the registry did not oblige. So we don't know whether they understood no problem to mean give them or they didn't. But we ask Mr. Chairman that the court commands that please hand over those rulings now because they are ready.
I think, sir, let me clarify on those issues. The question of the record of the proceedings, the ruling you are talking about, the registry falls under my office. As you can see, we have worked throughout the whole day. There is no way you are going to force the registry to hand over the ruling now. You can come for it tomorrow, but you cannot say I want it now. Secondly, the question about appealing and the record of proceedings, I advised this court that a ruling, you appeal against the final decision of court, and therefore you cannot try to turn out words to convince the chairman. When I advised the court to wait to take it, and we have finished. So the next time is adjourning the next date, and any matter arising, we shall take it from there. That is all, sir. Otherwise, all they are, whatever they are seeking, I think we are being off track. We need a date for the
Mr. Chairman, a very brief rejoinder.
For me, I am mandated to advise on the court, and when I address the court, it's not me to give me a state or whatever. No. That is my role.
We also, in respect, have a role to persuade the court not to take the advice, especially when it's deliberately misleading.
Not when I have talked.
Ceasefire Council, Senior Council, Karoa. We are adjourning this case, and if there is any matter, will be raised on this adjournment. Captain Dennis Ora,
Mr. Chairman, if I may
Colonel
ask,
Dr. Tired,
if I may inquire, Mr.
and
Chairman.
Hajji, your case is adjourned up to that field,
Mr. Chairman.
24. for further measures.
Just seeking clarification, Mr. Chairman. Are there investigations going on? Are there investigations going on? They just say are there investigations? And who is conducting the investigation?
So that's what I am saying. On the next item,
We shall overcome. We shall overcome. We shall overcome someday. Deep in my heart, I believe we shall overcome someday. We'll die. We'll die. We'll die someday. Deep in my heart, I believe we'll die someday.
Tekayo nawe.
Ntadde mama obukambwe obusungu mama
Nagwe nawe.
bagambe abasembeze Sura Sura
In a few minutes we get out of this place.
We are good. Yeah, more than.
Just to express our surprise this evening, the court appears to have been hijacked totally by the judge advocate who is giving the orders, although the regulations are very clear that he gives the advice and the court can refuse to take his advice for good reason, which must be recorded. That to us means that we, the defense, can persuade the court not to take the advice of the judge advocate when it is misleading. But it's now no longer possible in this court because it's under total control of the judge advocate One wonders then, what is the use of having a panel if the judge advocate makes all the decisions? Right now, the court refused to grant our request for a reference to the Constitutional Court on various questions, including the question of discrimination, because bringing civilians to a court-martial is discrimination when other civilians are being taken to the courts of judicature. We also challenged the territorial jurisdiction of the General Court-Martial. Our clients, Dr. Kizza Besigye and Mr. Lutale, were arrested in Kenya. Courts of Uganda have limited jurisdiction, limited to the territory of Uganda. So we had various constitutional questions, including the question of the arrest and incarceration of lawyer Aaron Kizza, who is part of the defense team of our two clients, and his absence disables their ability to defend themselves effectively. These are very substantial questions, but the court has declined, and when we have sought to appeal their ruling, and the law clearly says we have a right of appeal and uses the mandatory language, shall. The court, through the judge advocate, has declined, and even declined to hear our arguments. We are leaving this place very sad, not able to know whether the court is still going to function or it's the judge advocate, because he has totally hijacked the proceedings.
Yes, Uganda. Uganda.
There was supposed to plea of your individuals, the ones that you were representing in the courts of law. The plea was taken as not guilty, but yet they rejected taking.
You see, we maintain, well, our clients insist they are not subject to martial law. Yes. It's the reason they have declined to take a plea. We have persistently put across that argument. We have invoked all the relevant laws to back up that argument that our clients are not subject to military law. They are not subject to martial law, and therefore this court has no jurisdiction to try them here. So they have refused to submit to the jurisdiction of this court, and that is the reason they are not taking a plea. And it's one of the reasons we sought for leave. No, actually not leave. It's one of the reasons we had made the application to have a reference to the Constitutional Court. The jurisdiction of this court, including those matters the Constitutional Court has pronounced itself persistently, even after the Kabazikuluka decision. Because every matter that has gone to the Constitutional Court, the verdict has been the same. The pronouncement has, and it is self-executing. We get a shock of our life when the prosecution said, we need an order of enforcement, of execution. When indeed the constitutional pronouncement or pronouncements of the Constitutional Court are self-executing. So, we still maintain our clients are not subject to martial law, and this tribunal has no jurisdiction over them, and they will not take a plea before them. That's exactly what has happened today.
And the plea that has been entered?
Yes.
And the plea that has been entered by that very court, because the court registered as not guilty.
Yes, it's a right for one to say, I'm declining to take a plea. And it's up to them to record whatever plea they want, whether it's a plea of guilty or not. But in law, once one declines to take a plea, they are obliged to do to record a plea of not guilty.
But they should also record that our clients refused to take plea, therefore the court has entered a plea of not guilty. So we are hoping that the registry will keep accurate records. The registry which the judge advocate tells us he is in charge.
So tugamba bakirayansi baffe bawakanya obuyinza bwa kkooti eno okubawozesa mu nsonga nnyingi zonna zetayinza kuddamu wano, naye zonna nga mulabye nti kkooti eno terina buyinza kuwozesa misango gye bagamba nti gyazzibwa Kenya oba Greece oba Geneva, n'okuba nti babaleeta nga tebayise mateeka amatuufu ag'extradition, n'okuba nti nno kkooti eno terina buyinza ku ba civilian. Ekintu kkooti etaputa ssemateeka kyezeddamu enkya n'eggulo entakera n'emisango gyonna ne tugireeta wano. Nekitwewunyisizza buli application gye tuteekayo dismissed, buli ke muteekayo tukagobye, so buli kye tuleeta bagoba bugobi. Awo naakula etteeka ssemateeka akirambika bulungi Article 137 nti singa oli pate emu bw'ebeesabye nti ensonga zino zigende mu kkooti etaputa ssemateeka, ono bano tebalina buyinza buzigaana nazitaputa, balina buyinza buziframinga. Naye omulabye amenye ssemateeka ey'ennyingo 137 ye n'agamba nti tagenda kuziwaayo, agaanye. Ekyokubiri, akawaayiro 225 aka UPDF Act kagamba nti atamatidde na nsala ye mu nsonga zonna n'engeri proceedings ezitambulamu oba omusango gye baguddukanyamu waddembe okwekubira endulu mu kkooti esingawo. Ekyo nakyo agambye nakyo tugaanye. Obuyinza nga judge advocate yalagira nga senior counsel wabagambye nti judge advocate ng'akomandinga bukomandinzi kakati ye yeefudde amateeka. So judge
Thank you.